Hi, everyone, and welcome to Crime in Court. My name is Heather, and this is the Canton cover up series Commonwealth versus Karen Reed, episode 109. Karen Reed takes it to the federal court, or federal Supreme Court, I should say. And as you can see on the thumbnail, we have Martin Weinberg, who is her lead appellate attorney, with him also writing this motion are her attorneys, and the what's his name? Michael Pabian is the other appellate attorney on this case with Martin Weinberg. So they are writing this motion together. And so we're going to go over this. This is a 700-page filing, 699 to be precise, filing with the federal state court. So um, I lost my train of thought there for a second. The SJC, who is the one that just recently came back, they denied the I guess Karen's petition, her motion for some relief for her double jeopardy claims, where she claims that she has been acquitted on charges 1 and 3, even though it wasn't stated in open court, which is basically the only argument that the SJC had. It wasn't stated in open court, therefore it didn't happen. So, even though at least 5, possibly 6 jurors have come forward and said unequivocally they acquitted her of charges 1 and 3, and they were only stuck on the lesser charges of charge 2. So there was a whole bunch of mess and confusion going on in the deliberation room regarding that, but not regarding 1 and 3. They knew those were acquitted. All right, so we're going to get started with reading this. Let me shrink myself here. So this is the memorandum in support of petition for writ of habeas corpus. Now comes the petitioner, Karen Reed, by and through undersigned counsel, and hereby respectfully submits this memorandum in support of her petition for writ of habeas corpus under 28 U.S.C. So we've moved on. Like I said, the SJC was like their state Supreme Court, so now we're moving up to the federal level here to get some relief that way. Ms. Reed is currently facing an April 1st, 2025 retrial in Norfolk Superior Court. I don't believe that this is going to happen on April 1st now after they filed this. So I have been kind of doing a countdown on X for how many days to trial, except now I don't think we're going to trial April 1st. I kind of thought it was not very likely to begin with, but I definitely don't think it's happening now. So this was after her mistrial. Now she's facing a trial April 1st. This petition contends that such retrial will violate Ms. Reed's Fifth and 14th Amendment protections against double jeopardy. The petition relies upon post-trial statements of 5 jurors, 4 directly and 1 indirectly, and another juror who is not one of these 5 jurors, did an interview with Turtle Boy, Aiden Carney, who we're going to read through his motion to dismiss coming up soon too. So we'll read through that, even though there's some redactions, but we'll get through that. So Aiden did an interview with multiple jurors. One of those jurors happened to be he happened to do 3 interviews. So he did 2 written interviews, and then he actually did a live interview on Turtle Boy Live, with his face on the camera. So he actually was brave enough to come forward and talk about some of the things that were going on in that deliberation room. His name is Ronnie. It's a great episode on Turtle Boy Live if you missed it. I definitely recommend watching. It's quite eye opening and jaw dropping at the same time. So he also stated that they were acquitted, or that she was acquitted on charges 1 and 3. So we have 5 jurors that are listed in this memorandum or motion, but there actually was a 6th juror. He has Turtle Boy has identified that he is not one of the five. So that is six jurors that have unequivocally said she has been acquitted. So I just wanted to clear that up because it's six, really, not five, but they don't have it in like writing from that sixth person other than coming from Turtle Boy being a source for Turtle Boy. So all right, so the petition relies upon post trial statements of five jurors, four directly and one indirectly, that the jury in Ms. Reed's first trial reached a final unanimous decision to acquit her of second degree homicide. Despite massive media publicity regarding these declarations, none of the seven jurors disputed the accuracy of these post trial statements. So nobody disputed this once these were coming forward. There were multiple jurors coming forward and stating the same. They were coming to both the Commonwealth and the defense. So even the Commonwealth, if you recall, Lolly got phone calls, but he said he never reached back out to any of them because it would violate the deliberative process, which is a bunch of hooey, because they were trying to clear up the fact that there was a verdict, but it just wasn't stated in open court. So they were trying to fix their error when this happened. All right. So in the usual course, the jury's verdict would have been announced in open court, and re-prosecution for that charge would indisputably be constitutionally prohibited. Here, however, the trial court, assuming but not verifying that juror notes indicating an impasse referred to all rather than just several of the outstanding charges, failed to inquire, pursuant to Mass Crim P 27B, regarding the existence of any partial verdicts, as well as failing to poll the jury. So she didn't look for partial jury if there was a partial verdict, and by doing that, she would have, or by polling the jury, that's how she would have remedied that. And for the reason the jury acquittals were not announced and the mistrial was declared without the defendant's consent. Contrary to longstanding federal as well as state case law, the trial court gave no consideration to any of the existing viable alternatives to a mistrial, nor was defense counsel consulted or given any opportunity to be heard prior to and in relation to the court's declaration of a mistrial. We've gone over this multiple times. When this happened, she basically, how it normally should have gone, she received the note and she should have showed the note to counsel and then called in the jury and then polled the jury and given the defendant opportunity to speak. So those all would have been opportunities for or not all, but those would have been a couple times for the defendant to have some kind of say in a mistrial or, to be able to object to it or whatever the case may be. But they weren't even given that chance because, as it so happened, in order, Bev received the note. She did not show counsel. She immediately called in the jury, read it right back to the jury, and said, "I'm not going to make you guys go back and and keep deliberating, so I'm calling a mistrial." And she excuses them. There was no time for the defense to say anything, let alone to object to it or to even look at the note. Contrary to longstanding federal as well as case law, there was no consideration for mistrial. Sorry, I read that already. At no time prior to the trial court's final sua sponte, meaning on her own, she just on her own decided to respond to a jury note by declaring a mistrial, had the trial court even mentioned the word mistrial. In these circumstances, the Commonwealth did not satisfy its heavy, well established burden of establishing manifest necessity as a condition precedent for the mistrial, which was declared in violation of the petitioner's double jeopardy rights. Basically, she didn't do everything she should have done in order to avoid a mistrial. The defense independently maintains that a jury's final unanimous agreement that Ms. Reed is not guilty constitutes an acquittal for double jeopardy purposes, and that the trustworthy and uncontradicted post trial affidavits entitle her, at a minimum, to a judicial inquiry on the issue. And that is what I've been saying. The SJC really, in my opinion, failed on this because they should have done at the minimum this. Have Judge Bev call back the jury. It doesn't have to be on live TV. We don't have to see it. It could be in chambers or whatever. But call them back in and question them regarding, was there an actual verdict? And what was the problem? Why didn't they tell us there was a verdict? Oh, yeah, because there was Ronnie, the juror, and another juror wanted to ask the judge questions about what do they do if they have a split verdict? Does it have to be all or nothing? And the jury said, or other members of the jury, including the foreman, said, no, we're not going to ask Bev any questions. We're just going to keep going along like it's all or nothing. So that's what they did. So there's a lot of things that they could be, where they could find some errors here. The prosecution wants this court to, in essence, ignore the declarations of the jurors, ignore the possibility, if not probability, that the jury unconditionally, finally, and without any ambiguity unanimously found Ms. Reed innocent, and avoid any post trial inquiry that could demonstrate that all 12 jurors unanimously rejected the sufficiency of the prosecution as to 2 of the 3 indictments. So, do I need to break that down? Basically, I mean, this is really well written. Let's read that again. So, ignore the possibility, if not probability, that the jury unconditionally, finally, and without any ambiguity unanimously found Ms. Reed innocent. So, they need to, these declarations of the jury, even Judge Canoni, for the purposes of her response to deny the um, to deny dropping the charges, she said, I'm taking them at their word. I'm taking these affidavits from these jurors at their word. They really did acquit her, but I still deny it because it wasn't on paper and it wasn't said in open court. And that's basically the SJC's argument as well. So, I mean, they sided basically with Judge Bev's arguments. So, I'm so glad that they're taking this federally because I think that this case could be a, like a landmark case. It could really change the way things are done, possibly in Massachusetts and maybe everywhere. So, this is, what I was going to say is like, previously I said that this is a 700-page document. We're not reading the whole thing, by the way. It's only a 35-page brief. We will read through most of it, if not all of it. But we won't go through all of the exhibits. The rest of the document are exhibits and things like that. So we won't do examples and whatnot. But I just wanted to let you know it's not going to be a 8-hour stream. um, so what else was I going to say? Oh, please hit that like button. I always forget. Please hit that like button as it does help the algorithm. All right. So um, they're also avoiding a post-trial inquiry, which could have flat out rejected the charges 1 and 3 if they would have actually like called the jury back and um, did a post-trial inquiry. This could have identified whether the prosecution met their burden or not, and that's all that we were asking. So, or the defense is asking. So the defense has more than met its burden of production regarding the jury's decision to acquit Ms. Reed. Neither the trial court nor the SJC held otherwise. Instead, the state courts erected an impenetrable procedural barrier to prevent Ms. Reed from proving what is clearly true. So they are she isn't even able to prove her case because they're not letting her ask the jury any questions, either in court or, through attorneys and affidavits or by, bringing them in for this post-trial inquiry. They've been basically told they can't do anything about this, and they're just pushing forward full steam ahead with all three charges. How is that fair? Let's move on. That the jurors finally and unanimously agreed that Ms. Reed did not commit the homicide nor a second charge of leaving the scene for which she stands charged. This ruling is irreconcilable with the constitutional interest in having decisions by jurors respected and honored. So they are not respecting the whole jury deliberation process if they're not even going to accept that there was a verdict in this case. Public respect for the judiciary requires that agreements reached by a jury of the defendant's peers in a matter so consequential not be rendered irrelevant. For these reasons, federal courts favor post trial voir dires, and the denial of such inquiry here violated. The denial violated Ms. Reed's Fifth, Sixth, and 14th Amendment federal Constitution rights. So that's three separate rights that have been violated by not allowing Ms. Reed the opportunity to defend a verdict that was or wasn't told in open court. I mean, they didn't even have the opportunity to say it in court. All right, procedural background. On June 9th, Ms. Reed was charged in three separate indictments with second-degree homicide, manslaughter while operating under the influence of alcohol, and leaving the scene of a collision resulting in death in violation of all of those statutes, Massachusetts general laws. A jury, we have a footnote here. It says the record appendix for Ms. Reed's appeal to the Supreme Judicial Court is attached as Exhibit A to this memorandum. The citations to that record appendix are correspond to the page numbers in the lower left-hand corner. Okay, we're not going to look, but that's for reference for when they are looking through all of the many exhibits. All right. So, a jury trial began in Norfolk County Superior Court on April 16th, 2024. The trial court declared a mistrial on July 1st, 2024. After the mistrial, Ms. Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending that the jury reached a final unanimous decision to acquit her on those charges and that there was no manifest necessity supporting the mistrial. As set forth in more detail, the motion was predicated in part upon affidavits by counsel reflecting statements of four deliberating jurors that the jury had agreed Ms. Reed is not guilty of the relevant counts, and a secondhand statement attributed to a fifth juror stating that the jury had agreed Ms. Reed is not guilty of homicide. On August 22nd, 2024, after hearing oral argument, the Superior Court issued an order denying Ms. Reed's motion to dismiss. We've read through that in another video. On September 11th, Ms. Reed filed a petition for relief to the Supreme Judicial Court pursuant Mass General laws. On September 19th, 2024, a single justice of the SJC, Justice Dewar, reserved and reported the case without decision to the full court. On February 11th, 2025, the SJC issued an opinion hereafter, uh, named just the opinion, attached as Exhibit B to this memorandum, affirming the denial of Ms. Reed's motion to dismiss. So if you want to read their response, that's also in the attachments here. So the parties' briefs filed with the SJC are attached as Exhibits C, D, and E. And I will give you a link to this document that I'm reading, and you can go and look through this on your own on the exhibits there. Where was that? I always lose footnotes. Where'd it go? Okay. So on February 11th, the SJC issued an opinion, which is Exhibit B to this memo, affirming the denial of Ms. Reed's motion to dismiss. The SJC held that the trial court acted within its discretion in deciding that the jury was at an impasse and that a mistrial was therefore supported by manifest necessity, notwithstanding that the jury never clearly stated that the impasse extended to all counts. Basically, the manifest necessity, if that's confusing, it means like it had to be. There was no other option. But she didn't look for potential other options like was she acquitted on all counts or just one or what? So she didn't look at other possibilities or if deliberating was even a possibility, even though, stating so in their letter or notes, she still she couldn't force them, but if they chose to continue discussions, they could on their own. So there were other things that she could have asked or said or done, and she didn't do anything. So that's kind of what that manifest necessity means is like she didn't take every precaution to prevent a mistrial because it's the least favorable option usually. So notwithstanding that the jury never clearly stated that the impasse extended to all counts, and the post trial affidavits make clear that it did not, and the trial court adequately considered alternatives to a mistrial, notwithstanding that the court's intention of declaring a mistrial was not so much as mentioned until the trial court, on her own, declared one. The trial court was not required to consult with counsel or give counsel an opportunity to be heard regarding the prospect of a mistrial because it had previously solicited counsel's views on whether to give a Tui Rodriguez charge designed to prevent a mistrial in response to the jury note. So that what they're saying here is, whoops, what they're saying here is that she took basically the fact that they wanted the defense wanted the Tui Rodriguez charge read. She took that as yes, they were consenting to a mistrial, basically in her response, in her notes back to in her order back to the defense. Also, the lack of a formal verdict announced in open court precluded any later claim that the jury, in fact, had unanimously and finally decided to acquit Ms. Reed on two of the three charges against her, and the defense was not entitled to a post trial inquiry to substantiate its claim of acquittal because the availability of such inquiry is limited to claims of extraneous influence of juror bias. Um, she was saying she couldn't bring them in because now they could be influenced or have some bias when and that she also claimed that it, disrupted the sanctity of the deliberative process. That was another one of her arguments there. So Ms. Reed is entitled to federal review of her double jeopardy claim prior to retrial. Because Ms. Reed is currently released on bail, she is in the Commonwealth's custody as required to file a petition. The First Circuit has made clear that a petition for habeas relief that raises a colorable claim of former jeopardy need not invariably await trial and conviction in a state court. So you don't have to wait. You should be able to do something about that. Such claims are distinctive because the Constitution insists that courts may not impose more than one punishment for the same offense, and prosecutors ordinarily may not attempt to secure that punishment in more than one trial. So it's as if they lost the first time around, so they're trying again. As the Supreme Court has observed, the rights conferred on criminal accused by the Double Jeopardy Clause would be significantly and undermined if appellate review of double jeopardy claims were postponed until after conviction and sentence. So they're saying don't wait until she's been convicted and sentenced at a second trial, if that happens, God forbid. But they're saying this should be remedied now, and this is coming from the Supreme Court. This brief is kind of regurgitating back other cases from the Supreme Court. So, to be sure, the double jeopardy clause protects an individual against being twice convicted for the same crime and the aspect of the right to be fully vindicated on an appeal following final judgment. However, this court has long recognized that the double jeopardy clause protects an individual against more than being subjected to double punishments. It is a guarantee against being twice put to trial for the same offense, for being persecuted rather than prosecuted. In my opinion, they are persecuting Karen Reed. Obviously, these aspects of the guarantee's protections would be lost if the accused were forced to run the gauntlet a second time before an appeal could be taken, even if the accused is acquitted or, if convicted, has her conviction ultimately reversed on double jeopardy grounds. She has still been forced to endure a trial that the double jeopardy clause was designed to prohibit. So it fails her constitutionally as well because she still has to go through the rigorous, uh, tremendously stressful process of going through another trial, having to sit through that again, having to pay for it. It's an extreme burden to be persecuted or prosecuted. But then when the state is coming at you with the full weight of its power, and you're just a girl who happens to have some supporters because her story got out. I mean, thankfully from Turtle Boy. But other than that, I mean, she's anybody. She's anybody in the state of Massachusetts or any state for that matter that has a justice system that's being weaponized against the people. She's any of us. She's any of us. And that's why this case is so frustrating and why we're all so passionate about it. To realize the solemn promise of this constitutional guarantee, federal habeas courts will, in appropriate circumstances, entertain a claim that permitting a nascent but as yet incomplete state court prosecution to go forward would violate the double jeopardy clause. For reasons set forth in section 4, the defense contends that Ms. Reed's retrial on counts 1 and 3 would violate her federal constitutional protection against double jeopardy. Accordingly, Ms. Reed may seek federal habeas corpus relief without first undergoing trial on the challenged indictments. Because the double jeopardy clause protects interests wholly unrelated to the propriety of any subsequent conviction, a requirement that a defendant run the entire gamut of state procedures, including retrial, prior to consideration of her claim in federal court, would require her to sacrifice one of her protections of the double jeopardy clause. Basically, again, reiterating the fact that having to go through another trial before this is decided, it would put her through more burdens to go through trial and be having to endure that again. All right, so the facts. On June 25th, 2025, the jury in Ms. Reed's first trial began deliberations after receiving instructions from the trial court. The court instructed the jurors, "You should continue deliberating until you have reached a final verdict on each charge." It also noted that count 2 contained lesser included charges of voluntary manslaughter and motor vehicle homicide, which the jury should consider even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle. So these jury instructions were awful. So the lesser included, the one that they got hung up on, she said in her jury instructions, Judge Bev said that they should consider the lesser included charges of involuntary manslaughter, even if the Commonwealth failed to prove their case. Huh? Why would you be able to do that? That makes no sense and shouldn't be allowed. So that's another issue here. The following day, on June 26th, 2024, outside the presence of the jury, counsel for Ms. Reed raised an issue regarding the verdict form. Guys, remember that? Something funny, Miss Reed? As she yelled at Karen and said, "We're done here," and walked out. With respect to count two, the original slip provided only one option to find Ms. Reed not guilty before going on to ask whether Ms. Reed was guilty of the offense charged or guilty of one of the two lesser included offenses. Counsel asked that the form be amended to provide a not guilty option for the subordinate charges under count two. The trial court initially indicated its disagreement with counsel's request. However, after considering the matter further and acting like a fool, the court came back and agreed to provide supplemental instructions and an amended verdict slip. Later that day, the court provided the supplemental instructions telling jurors that count two encompasses three separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on that lead charge, and if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order. How does that make sense? But cool, that's her instruction. On June 28th, the jury sent the following note to the court. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. The court asked counsel for their views on whether there had been due and thorough deliberations sufficient to support the giving of a so-called Tui Rodriguez charge. And we have down here it says, in the SJ's words, the Tui Rodriguez charge is a model instruction given when jurors report a deadlock after due and thorough deliberation that is designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. So it's actually designed not for a mistrial, but to reach a verdict, to urge the jury to reach a verdict is what the Tui Rodriguez is designed for. According to the SJC, the Commonwealth responded that the charge should not be given because there simply hadn't been sufficient time. Counsel for Ms. Reed disagreed, requesting that the court read the Tui Rodriguez model instruction and go from there. The trial court sided with the Commonwealth, ruling, I am not prepared to find that there have been due and thorough deliberations at this point, so I am going to send them back out. On July 1st, the jury presented another note stating, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions, which shouldn't come into play, and state of mind. The divergence in our views are not rooted in lack of understanding or effort, but deeply held convictions. Your deeply held convictions shouldn't be keeping you from a verdict, but whatever. So yeah, or our effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. Upon being asked by the court, the parties reiterated their same previous expressed views with the Commonwealth, taking the position that due and thorough deliberations had not yet occurred, and Ms. Reed's counsel arguing that the court should give a Tui Rodriguez instruction. This time, the jury court decided to give the requested instruction. Later that day, the jury sent yet another note thereafter without reading the note to counsel and without providing counsel with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges. The trial court simply stated the jury is at an impasse and immediately called in the jurors. It then read the note on the record. Despite our rigorous efforts, we continued to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. How? I don't know. Conversely, others find that the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. This right here, individual principles and moral convictions, makes me believe that they felt like she was drinking and driving, and which they didn't even prove other than, okay, well, she admitted in one interview that she had a couple drinks, but they didn't even prove the number of drinks that she had. They didn't prove that her extrapolation was accurate and could be verified, and it wasn't even taken in the proper way or manner in which they should have taken it for criminal procedures. It was taken at the hospital without really her consent. And yeah. Anyways, so I think that somebody felt, well, she was drinking and driving, and so she must have been drunk, and she obviously, she needs to be punished for something. So I think that's is what people were holding on to because she said you can still look at these lesser includeds in the manslaughter, even if the Commonwealth didn't meet its burden on the manslaughter charge. What? Which is one of those was driving drunk, an OUI, something or other. Homicide by OUI or whatever, however it's phrased. All right, so after reading the note and without soliciting the views of counsel in any respect, the trial court stated, I am not going to do that to you folks. Your service is complete. I am declaring a mistrial in this case. The jury was then excused in order to leave the courtroom. Counsel was not invited to speak during this entire interaction. The following day, on July 2nd, 2022 or 2024, sorry, unsolicited by any party, one of the jurors, Juror A, contacted one of the attorneys for Ms. Reed, Alan Jackson. Juror A stated that he or she wished to inform Attorney Jackson of the true results of the jury deliberations. That's according to an affidavit. For the purposes of adjudicating Ms. Reed's double jeopardy claim, both the trial court, meaning Judge Bev, and the SJC accepted that the jurors' statements were true and accurate. But yet, they didn't do an inquiry to bring in the rest of the jury. They didn't believe it enough to say, okay, well, maybe she was acquitted and we should do something about it. Nope, they didn't believe it. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree homicide. Juror A was emphatic that count 1 was off the table and that all 12 of the jurors were in agreement that she is not guilty of such crime. The jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury/death. One day later, on July 3rd, 2024, another attorney for Ms. Reed, David Yannetti, was contacted by two different individuals, hereinafter Informant B and Informant C, who both received information from two distinct jurors, hereinafter Juror C and Juror C, Juror B and Juror C, both of whom were part of the deliberating jury in this case. Informant B sent Attorney Yannetti a screenshot that he or she had received from someone, the intermediary B, of text messages that they had received from Juror B. In that screenshot, Juror B texted the following to the intermediary. It was not guilty on second degree and split on half of the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. And that is an error in what they texted or typed or whatever it was. Juror B later placed an unsolicited call. So, Juror B, the one who their statement got out by this intermediary, now they're coming straight to Attorney Yannetti to say that yes, they are confirming the information contained in the publicly filed affidavit was accurate. Juror B clarified the statement, saying, however, that he or she meant to say no one thought she hit him on purpose or even knew that she had hit him. So that is the clarification on that. Juror B further told Attorney Yannetti that he or she believed that every juror or every member of the jury, if asked, would confirm that the jury reached not guilty verdicts on counts 1 and 3. So they're like, yeah, call us in. We would love to come in. Ask us. I bet you every single one of us will say we acquitted her on 1 and 3. Informant C has been in contact with another individual, also intermediary C, who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. So intermediary C is on a Zoom with Juror C. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C. So intermediary C is on the Zoom with Juror C. They're talking about the trial. Intermediary C goes to informant C after they get off the Zoom and sends them screenshots. This is what they say. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary. No consideration for homicide 2. Manslaughter started pulling at 6-6, then ended deadlock at 4 no, 8 yes. Informant C says, interesting. If it was no consideration for homicide 2, shouldn't she have been acquitted on that count and hung on the remaining charges? They said chargers, but meant charges. Goes back to the jury verdict slip that was all confusing. Yep, Judge Bev did that on purpose, in my humble opinion. Intermediary C says she should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. After the filing of Ms. Reed's initial motion to dismiss, but before the Superior Court hearing on that motion, Attorney Jackson was contacted by two other deliberating jurors. The first, Juror D, stated that the jury reached not guilty verdicts on count 1 and count 3, and that the disagreement was solely as to count 2 and its lesser offenses. He or she recounted that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen on 1 and 3? Juror D unequivocally told counsel, every one of us will agree and acknowledge that we found Karen Reed not guilty of count 1 and 3 because that's what happened. This is now another juror saying, ask us all. We will all tell you the same thing. So they are begging for an inquiry. They were denied by both Bev and Beverage, as some people call her, and or somebody said Bev vodka. That's a good one too. Maybe that's what's in her Yeti. Uh, but anyways, so Bev and the SJC both denied that opportunity for an inquiry, which the jurors seem to be begging for. Juror E similarly stated that the jury was unanimous on 1 and 3, that Karen was not guilty of those charges. The Commonwealth filed a post-trial notice of disclosure informing the court that on Sunday, July 21st, 2024, Assistant District Attorney Adam Lawley received an unsolicited voicemail on his office's phone line from an individual who identified themselves as a juror by full name and seat number. The message stated, "It is true what has come out recently about the jury being unanimous on charges 1 and 3." ADA Lally received a subsequent message from the same individual stating he could confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3 guilty on the manslaughter charges. The Commonwealth additionally received emails from 3 individuals who identified themselves as jurors and indicated that they wished to speak anonymously. The Commonwealth declined to substantively respond to the voicemails or emails, instead claiming in responsive emails that it was ethically prohibited from discussing such matters, which is a bunch of hooey because they weren't going to be infringing on the sanctity of the deliberative process. They only needed to confirm if she was acquitted or not, which never happened. So, re-prosecution on 1 and 3 will violate Ms. Reed's double jeopardy rights. Standard review. Because Ms. Reed is awaiting trial on state criminal charges, she is not in custody pursuant to the SJC's judgment. Accordingly, this petition it was vacated on other grounds and subsequently reinstated, whatever that means. Accordingly, this petition is brought under 28 USC section 2254. Restrictions on the scope of habeas review therefore do not apply. Instead, the court must defer to the SJC findings of fact, but must undertake plenary, why can't I say that word? Review of the court's resolution of issues of law. Habeas petitions governed by 2241 are not subject to the heightened standards contained in 2254. Ordinarily, a motion to dismiss on double jeopardy grounds rests on a pure question of law that the court reviews de novo. What does de novo mean? I forget. I've looked it up before and I don't remember. I'm keeping my eye out because we just got today the motion for misconduct or motion for dismissal due to government, misconduct or whatever. And so I'm waiting for it. It's still not available. We have a motion to impound some of it, so I think we're waiting on approval from the judge for that impoundment. What was I looking up? De novo. Means anew, from the beginning. So ordinarily, a motion to dismiss on double jeopardy grounds rests on a pure question of law that court reviews from the beginning on its own. Anew. So the constitutional protection against double jeopardy. The ancient right to a jury trial is no more procedural formality, but rather a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury, beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Prominent among, so basically, there are protections in place, and this double jeopardy is to protect citizens from receiving the brunt end of prosecutorial overreach and misconduct and arbitrary convictions. So, prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them, in many cases, of the benefits of trial by jury. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. So the jury process is what keeps it going. Trial by jury. It's what makes the judicial system breathe. And without the sanctity of upholding their verdicts, what do we have? It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. The Double Jeopardy Clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life and limb. That's Bluford versus Arkansas. They've cited that many times before. That's quite a famous one for Double Jeopardy. The underlying idea, one that is deeply ingrained in at least the Anglo American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which he or she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. At the heart of this policy is the concern that pertaining the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. So basically saying if you are able to continually, come at the a citizen for second trial, third trial, however many tries, you are becoming an oppressive government. You're not necessarily here for the good of the people. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Reprosecution is barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. As a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. This rule is rooted in the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Meaning she has the right to be up in front of a jury that she believes might listen and give her a fair trial. Um, yeah, and this what the rule is, the importance of having a jury that she has faith in, a jury system that she has faith in. So the double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, after a mistrial has been declared without the defendant's request or consent, the permissibility of retrial depends on whether there was a manifest necessity for the mistrial. The power to discharge a jury without a verdict ought to be used with the greatest caution under urgent circumstances and for very plain and obvious cases. So, Again, you shouldn't be calling a mistrial just willy-nilly like Judge Bev seems to do because she had two in a row. She had a trial previously, another officer who lost his life. I believe it was in the line of duty, and that person on trial for his homicide, there was a mistrial also because Judge Bev doesn't know how to rule her courtroom, in my opinion. Importantly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth, a burden that the state court erroneously placed on the defendant. So, there's been so much burden shifting in this case. It seems like because Karen came out with, putting forth evidence all throughout the proceedings and like little nuggets of evidence at hearings and things, because she's defending herself with facts and truth, it seems like she has the burden now to prove that there's some kind of conspiracy and cover up and whatever. And then people are like, oh, you're all just crazy. But she doesn't have the burden. The burden is still on the Commonwealth, although that burden shifting, if you listen to Ronnie's interview with Turtle Boy, they definitely were burden shifting and making the burden on the placing it on the defendant to have to prove her innocence, basically, which is the exact opposite of what our jury systems are supposed to do. But, anyways. In assessing whether the prosecution satisfied its burden on this point, the First Circuit has stated it is useful to consider the following three factors: whether the trial court consulted with counsel, whether the court considered alternatives to a mistrial, and whether the court adequately reflected on the circumstances before making a decision. Embracing both consideration of alternatives and consultation with counsel is the amount of time devoted by the judge to the mistrial decision. A precipitate decision reflected by a rapid sequence of events culminating in a declaration of mistrial tends to indicate insufficient concern for the defendant's constitutional protection. So she rushed through it. Um, she didn't allow any kind of comfort, not even confrontation, but just, response from the defendant or the opportunity for the defense attorneys to discuss the implications of a mistrial. She even said in an interview that she wasn't prepared for a mistrial. That wasn't what she was prepared for. She was looking, she was preparing herself for the worst and hoping for the best. But she wasn't even thinking about a mistrial at the time. So, kind of scary. They didn't even give her the opportunity to talk to her lawyers about that. And I missed a footnote here for some reason. Says the SJC did not find that Ms. Reed or her counsel consented to a mistrial, and for good reason, neither Ms. Reed nor her counsel requested or expressly consented to a mistrial. While consent may, in some circumstances, be implied from a failure to object, any such findings requires, at a bare minimum, that the defendant had an adequate opportunity to register an effective objection. For reasons discussed, no such opportunity was provided. So, basically stating that just because they didn't object at the time doesn't mean that they lose their objection. There was no there were no opportunities for them to place an objection effectively. Therefore, you can't fault them for not objecting. Basically, is what that says. All right. So, although in other circumstances, a reviewing court may defer to the trial court's discretion to make a mistrial decision, if the record reveals that the trial judge has failed to exercise the sound discretion entrusted to her, the reason for such deference disappears. So, her ability to show discretion goes out the window when she has not been able to show that she has been able to use such discretion in appropriate ways. And she's the epitome of not being appropriate as a judge. All right, stating the deferential review of a trial court's exercise of discretion as to when to declare a mistrial is appropriate only if it is clear from the record that the judge has given careful consideration to the available alternatives and to the defendant's interest in having the trial concluded in a single proceeding. Here, the SJC at the outset committed legal error by relying heavily upon the trial court's discretion without or not without notwithstanding that the record reflected no consideration of any alternatives to a mistrial. So the SJC basically made a mistake by allowing Judge Canoni's discretion in this particular instance because she didn't look for alternatives. She wasn't trying to remedy a mistrial before it occurred. There were other things that she could have done, which we've gone over. All right, so turning to the relevant factors, the first thing to be noted is that the trial judge did not give counsel an opportunity to object or discuss with them the advisability of a mistrial. Upon reviewing the final jury note, the court declared a mistrial and excused the jury without consulting counsel. Video footage, and they provide a link, and reinforces the suddenness of the court's actions. And I went over that. She was quick, and I went over the process and how she skipped some steps and was just like, "Okay, mistrial, you're done." So, video reinforces the suddenness of the court's actions and corresponding lack of any meaningful opportunity to be heard. At the opportunity, or at the approximate, blah, at the approximately 5 hours, 47 minutes, and 25-second mark of the video, the court took the bench and stated the jury is at an impasse. In contrast to the procedure followed as to prior notes, the note was not read to counsel. So in prior notes, it was, but this time it wasn't. Instead, the court immediately called for the jury to be brought in. The sound of a door opening or closing could be heard, and then at approximately 5 hours, 47 minutes, and 55 seconds, a mere 30 seconds later, the jury arrived in the courtroom. 30 seconds later. The court then read the note, which had not previously been provided or read to counsel on the record. At 5 hours, 49 minutes, and 23 seconds, the court stated it was declaring a mistrial and immediately discharged the jury at 5:49:30, a mere 7 seconds later. Yowza. All right. These circumstances did not provide Ms. Reed's counsel with a meaningful opportunity to be heard, finding lack of sufficient opportunity where, after hearing testimony regarding potential defect in jury voir dire, district court stated its intent to declare mistrial, then called for the jury to be brought in and discharge them. So you have to declare it first before you do it, before you bring the jury in and do it. At least that should be how it goes. Finding lack of sufficient opportunity to object where the district court only addressed counsel after reading and confirming the verdict in open court to ask if there was anything else before discharging the jury. So they even asked the jury, like whoever this was in this case, they asked the jury, is there anything else before I discharge you? And that would be your moment to speak up and say, "Well, yeah, what about a partial verdict? What do we do in this case?" That's when they would be able to have asked their questions that they had. They were expecting, and if you listen to Ronnie's interview, they were expecting the judge to ask some follow-ups, not just immediately dismiss them. So, legal and factual context renders the trial court's action even more unexpected. Legally, trial counsel was entitled to rely on decades of case law expressly requiring a full opportunity to be heard before the declaration of a mistrial. Factually, in response to multiple prior jury notes in this case, the trial court had advised counsel of the contents and afforded them time first to consider and then be heard regarding any issues raised. The trial court's deviation from that well known and accepted practice with respect to the final note was a precipitate decision reflected by a rapid sequence of events culminating in the declaration of a mistrial. It also deprived defense counsel of any opportunity to raise issues or even discuss potential remedies. Moreover, the defense respectfully submits that given the importance of double jeopardy, protections, and the profound implications of a retrial for a criminal defendant, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client, noting in finding lack of manifest necessity that counsel had no opportunity to discuss the prospect of a mistrial with his client. Counsel for Ms. Reed clearly had no such opportunity here. The SJC erred in multiple respects in ruling that the trial court's prior consultation with counsel was sufficient to excuse the absence of such consultation at the pivotal moment prior to any declaration of a mistrial. Basically saying she both the trial court and the SJC erred in the fact that they um, basically inferred from other conversations with counsel that they were okay with a mistrial. They never said that. It was discussion about a Tui Rodriguez charge that they were giving the jury, which is intended to to push for a verdict, not necessarily a mistrial. So Judge Canoni and the SJC are like, well, because you talked about the Tui Rodriguez charge before, it's okay to infer now that they're consenting to a mistrial, which is, that just doesn't make sense. So, first, the SJC erred in relying upon the trial court's solicitation of counsel's views in response to the first two jury notes. Those discussions related solely to the propriety of giving a Tui Rodriguez charge, which again is designed to urge the jury to reach a verdict and presents a distinct legal issue from the declaration of a mistrial. Defense counsel's request for a Tui Rodriguez charge implies that their desire was not to have a mistrial, but instead to have a trial court urge the jury to reach a verdict. So that is what should have been inferred if they were going to infer something, because that's the whole point of the charge. Second, the SJC was wrong in simply assuming that consultation regarding the third note would not have produced any fruitful alternatives. This reading of the silent record against the defense is contrary to the clear Supreme Court case law placing the burden of establishing manifest necessity on the prosecution. So it's not the defense's responsibility to be like, well, there should be other remedies here. It's on the court, the prosecution, the side that's pushing for that conviction. Indeed, the SJC's opinion does not so much as mention the appropriate allocation of the burden to the Commonwealth. Moreover, as set forth in pages 19 through 22, there were alternatives to the declaration of a mistrial, so it is far from clear that consultation would not have proved fruitful. So we'll get to that. We'll break it down as we get to it. The record is independently lacking on the second prong as it reflects no judicial consideration of alternatives to a mistrial. Here, there was one obvious alternative to simply ask the jury to specify the charge or charges on which it was deadlocked and or to ask the jury whether or not its final note related to all or less than all of the charges. So two remedies right there. Were you deadlocked on all the charges? And it's your final note referring to being deadlocked on all the charges. This option is apparent from the face of Mass R. Crim P 27B, which states that the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. So, before I declare a mistrial as a judge, I need to determine if there were any verdicts that were returned. And if so, make them, make sure that they are recorded on the record in open court and on the piece of paper, because that's the form that they want, in order for it to stick, in order for the verdict to be a verdict. In fact, the reporter's notes expressly indicate that such reception of partial verdicts is required, not just it would be nice. It's required before a mistrial may be declared for manifest necessity. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. Had the court inquired as to the existence of any partial verdicts, and the jury articulated its verdict consistent with the statements of jurors A, B, C, and D, and E, the double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. Basically, you cannot keep going after someone who has been acquitted. Um, yes, especially in a partial verdict, even in that case. So, when the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has assigned or reached agreement. So, partial verdicts should be recorded, stated in open court before a mistrial is ever even considered. That was not done. The First Circuit's decision in United States versus Toribio Lugo provides a helpful analog. There, in the midst of trial, upon noticing that only 11 jurors were present, the district judge consulted with both the prosecutor and the defendant's lawyers, outlining two options: either postpone the trial until the 12th juror could be located, or proceed with a jury of 11. Defense counsel conferred with her client and informed the judge that the defendant did not wish to proceed at the moment with 11 jurors, but rather would like to wait for the 12th member jury. Shortly thereafter, the judge learned for the first time that the missing juror had been absent during some or all of the earlier portions of the trial. The judge then announced that he was going to declare a mistrial because only 11 jurors had heard the evidence, and he did not believe that there was any way to cure that defect. The trial judge denied a subsequent motion to dismiss on the grounds that a mistrial was required by manifest necessity because only 11 jurors remained and the defendant had refused to proceed with fewer than 12. The First Circuit reversed, finding that there was a clear alternative to a mistrial proceeding with 11 jurors. While the district court had tentatively explored that alternative, it never exhausted it. The court never offered the defendant a choice between proceeding with 11 jurors or accepting a mistrial. In fact, during the pertinent time frame, the court made no effort to ascertain the defendant's attitude or wishes with regard to the possibility of a mistrial. In view of these omissions, the record compelled a conclusion that the jury of 11 alternative was not adequately explored. So they didn't totally explore the possibility of proceeding with the 11 jurors, so therefore that was overturned. This conclusion was dispositive because Where there is a viable alternative to a mistrial and the trial court fails adequately to explore it, a finding of manifest necessity cannot stand. And that, I mean, that's very applicable in this case. When there were alternatives, a mistrial should not be called. The present case reflects even less consideration of alternatives to a mistrial. While the trial court discussed the two prior jury notes reporting an impasse with counsel, it did so only in the context of deciding whether to give a Tui Rodriguez charge, and the court did not even mention the prospect of a mistrial. The SJC therefore legally erred in finding that the trial court's response to the first two jury notes reflected adequate consideration of alternatives to a mistrial. There is nothing in the record to indicate that the judge was considering a mistrial at the time. While the notes stated that the jury had reached an impasse on some charges, the test is not whether the judge considered that she had a potential problem on her hands, but rather whether she accorded careful consideration to the defendant's interest in having the trial concluded in a single proceeding. Oops, I didn't mean to do that. So the judge should have considered the fact that instead of dragging it out and making it a second trial, she should have tried to resolve it in one proceeding. That's what that's saying. So, with the record barren of any hint whatsoever that the judge was aware of the double jeopardy implications of her decision, the defense respectfully submits that this court cannot find that her discretion was sound. The statutory prohibition on ordering the jury to continue deliberations without consent was one among many factors that the trial court should have considered in consultation with the parties. So she could have sent them back. The statute would not have prohibited the trial court from simply asking whether the jury had reached a verdict on any counts or asking the jury whether its impasse related to all or less than all charges. Contrary to the SJC's suggestion, there is simply nothing coercive about asking a jury whether it had reached a verdict on some, but not all, separately charged counts. And that's kind of what the argument is coming from the Commonwealth and the judge. Like, well, I can't ask them because it would infringe on the whole deliberative process thing, and I can't. It's too, it's sacred. But it's not. And it's not coercive to ask, what was your verdict? Did you reach a verdict? It's not coercive. Affirming instruction that simply asked the jury to report any partial verdict it had already reached as non coercive. A court does not err if it asks about a partial verdict, even when it is clear that the jury is at an impasse and further deliberations would be fruitless. And we've got here Bluford held that before declaring a mistrial, the trial court was not required to permit the jury to return a partial verdict on lesser included offenses within a single charge. The Supreme Court explained that under Arkansas law, the jury's options were limited to two: either convict on one of the offenses or acquit on all. That's not how it should be. A case relied upon by the SJC also involves lesser included offenses within a single count. By contrast, where as here a complaint or indictment in multiple counts charges multiple crimes. A partial verdict is an available alternative under Massachusetts law. In a juvenile versus Commonwealth, distinguishing the situation where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. Moreover, the trial court could have alternatively informed the jury that it could not be required to continue deliberations without its consent and still asked it to retire to consider whether it was prepared to return any partial verdict. So, again, she could have said, "Well, I can't force you to go back, but you still can go back if you guys would like to. You can return any partial verdicts if you have at this time." She could have done other things, as we know. This Massachusetts statute, on its face, by permitting the jury to be sent back to continue deliberating with its consent, contemplates that courts may non coercively make a post tui Rodriguez inquiry to the jury as to whether it consents to continuing deliberations on all or less than all charges. Whether the trial court would have ultimately adopted any of these alternatives is beside the point. The dispositive fact for present purposes is that the record provides no indication that the trial court even considered available alternatives. As stated, the federal constitutional burden to justify a mistrial is clearly on the Commonwealth, yet the state court not only failed to identify that burden, but improperly placed the burden on the defendant on subjects such as the consideration of alternatives. So, again, Judge Canoni should have been coming up with the alternatives. It's not on the defendant to come up with the alternatives. They can, but they don't have to. It's not required. While the law is clear that a jury deadlock may constitute manifest necessity, the key to this principle, of course, is that the jury must be genuinely deadlocked. Here, it is possible to read the jury notes in the context of the trial court's instructions as reflecting an impasse on one count but not others. The jury's reference to charges is easily reconciled with the post trial affidavits affirming that the only deadlock related to the lesser included offenses of count two. Indeed, the trial court repeatedly referred to those lesser included offenses as distinct and multiple charges, both in its initial and supplemental instructions to the jury. In this context, the jury's final note was facially susceptible to two alternative interpretations. One, that the jury had reached an impasse as to all charges, or two, that the deadlock applied to only some of those charges. For example, multiple lesser included allegations within a single count, such as charge 2. It was not an unambiguous note affirmatively declaring an impasse on all charges as assumed by the SJC and Judge Canoni. Information received from jurors post trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it should continue deliberating until it had reached a final verdict on each charge. For these reasons, the SJC was wrong to characterize the juror affidavits underlying the defense motion as inconsistent with the jury notes. How are they saying they're inconsistent? Because they say it's all the charges. The jury simply never stated that it was unable to reach a unanimous verdict on any of the charges. The SJC did not mention, much less analyze, the reading of the notes set forth by the defense above. So the SJC didn't even consider the fact that you could read that note two different ways, which that's what we all were saying at the beginning of when this all started. So the trial court took no steps to clarify the jury's notes. In the double jeopardy context, where the Commonwealth alone bears the burden of establishing manifest necessity, this ambiguity must be read in the defendant's favor. Ambiguous verdicts must be construed in favor of the defendant. So, if you are to read that note in two separate ways, you're supposed to read it and give the benefit of the doubt to the defendant. So we resolve any doubt in favor of the liberty of the citizen rather than exercise what would be an unlimited, uncertain, and arbitrary judicial discretion. The SJC therefore erred in construing the jury notes as an unambiguous declaration of an impasse on all counts. In the Commonwealth versus Daniels, the jury responded by a Tui Rodriguez charge by saying it had not reached a unanimous decision on any of the charges. The trial judge then asked counsel for his position, and counsel said he did not object to a mistrial. Daniels does not, therefore, support the SJC finding that the trial court appropriately exercised its discretion. In any event, Daniels does not bind this court in its analysis of the federal constitutional issue. So I think SJC must have been uh, discussing Commonwealth versus Daniels, and they're saying, well, it's not comparative because it's different. In sum, a decision made so precipitately, precipitately, I don't know how you say that, could not have been the product of any careful consideration of the valued right of the defendant to have her guilt or innocence determined in a single trial. This in itself precludes the Commonwealth from retrying her on counts 1 and 3. The jury's unanimous conclusion following trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. What constitutes an acquittal is not to be controlled by the form of the action in question. Martinez versus Illinois. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged. Labels, including those provided by state law, do not control the analysis. That's McGrath versus Georgia. This is because whether an acquittal has occurred for purposes of the double jeopardy clause is a question of federal, not state law. So, first of all, they're saying an acquittal doesn't need to be so formal. An acquittal is an acquittal. And if that's what they did, was all of them unanimously acquitted her, even if it's not on paper or even if it wasn't said in open court, it still means she was acquitted. It doesn't deny that fact. Secondly, what they're saying here is it's not up to the SJC. This is a federal issue, not state, and therefore the federal courts need to make a decision on this. So the SJC's decision shouldn't even be considered here. Here, the affidavits by attorneys Jackson and Yannetti reflect statements by 4 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Reed is not guilty of counts 1 and 3, and an indirect statement by a 5th juror that they had agreed with respect to count 1. Both the trial court and the SJC, for purposes of ruling on the double jeopardy issue, proceeded from the assumption that the affidavits were accurate. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury's deliberations. Juror A was emphatic that count 1 was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Excuse me. Reflecting text message from juror B, it was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him. Reflecting juror C's statement relayed by intermediary C that there was no consideration for homicide 2 and Ms. Reed should have been acquitted on that count. Supplemental affidavit by Alan Jackson. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. Juror E explained that the jury was unanimous on 1 and 3 that Karen was not guilty of those charges. Despite significant publicity that accompanied the filing of the defense motion relying on jury declarations, none of the remaining jurors ever communicated to the court's staff, the district attorney's office, defense counsel, or the media that they disputed the accuracy of the 5 jurors' representations. In rejecting Ms. Reed's claim of acquittal, the SJC relied solely upon the lack of a formal verdict returned, received, and recorded in open court. So just because it wasn't put on paper and then read in open court, they're denying that it happened. This reasoning is rooted in formalism that has been consistently rejected by the Supreme Court in a string of precedents spanning more than 100 years. However, it may be in England, in this country, a verdict, however, it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. Holding that judicial grant of new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize trial judges to enter judgments of acquittals in jury trials. The double jeopardy clause prohibits re-examination of a court decreed acquittal to the same extent it prohibits re-examination of an acquittal by jury verdict, whatever that means. The Supreme Court has, for example, consistently refused to rule that jeopardy for an offense continues after an acquittal, whether that acquittal is expressed or implied by a conviction on the lesser included offense. Oh, I missed. Oh, no, I didn't miss it. It's right here. So the SJC's reliance upon an almost 90-year-old Supreme Court of Tennessee opinion, which has never been cited in any published federal court decision, is unpersuasive in light of the foregoing authorities. Additionally, so basically, the SJC is citing this 90-year-old Supreme Court filing that's never even been cited for federal um, court decisions. So yeah, they're using a case law that is not recognized by the feds. Additionally, Clark did not foreclose the success of the double jeopardy claim at issue. In fact, it expressly reserved such claim, observing, should the petitioner be again arraigned, the learned trial judge, if convinced that in truth and in fact all 12 of the jurors on the trial did agree and continued to the end of their deliberations to agree that petitioner was innocent and that they failed to so report only because of a mistaken conception of their authority. A mistaken conception of their authority. They didn't realize that they could do a partial verdict, perhaps, in the matter, may well conceive in his duty to exercise the right vested in him of advising the entry of a what? A null. Okay, we're definitely looking that word up. So give me one sec. What is it? Null? I can't even pronounce that. Prosecute? No, it doesn't give me a pronunciation, but whatever this phrase means is a legal entry that dismisses a criminal charge or a civil lawsuit. So it would be an entry into the record that it was dismissed. So basically, let's read that sentence again then. Where does that start? Oh, that's a long sentence. I don't want to read all that again. In fact, it expressly reserved such claim, observing, should the petitioner be again arraigned, the judge should, if convinced, in fact, all 12 of the jurors on the trial did agree and continue to the end of their deliberations to agree that the petitioner was innocent and that they failed to report only because of their mistaken concept of their authority in the matter, may well conceive it his duty to exercise the right vested in him of advising the entry of an acquittal, basically. So they should be, in this case, it should be an acquittal if all that I just read. I don't want to read through that all again. So if they're, should they be arraigned again? Yeah, if they have to go up again in court for the same crime, basically because the jury messed up from the first trial, then they should be acquitted. That's what that's saying. All right, under the SJC's ruling, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely, that cannot be the law. Indeed, it must not be the law. And in the context of this highly publicized case, it strains credulity to suggest that if the unequivocal statements of 5 jurors quoted above did not, in fact, represent the unanimous view of the 12, the remaining jurors would allow the inaccuracy to go uncorrected. So it's not believable that the remaining jurors that did not come forward would not have corrected the record if those other jurors were wrong. Instead, they would predictably have notified the Commonwealth or the trial court of their own recollection. Here, to the contrary, the Commonwealth has received the exact same information as the defense regarding the jury's unanimous agreement to acquit Ms. Reed on counts 1 and 3. The Supreme Court's decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, the foreperson had reported during deliberations that the jury was unanimous against the charges of capital homicide and first-degree homicide, but split on manslaughter. The court sent the jury back to continue deliberations. When the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited reprosecution for capital and first-degree homicide. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. The foreperson's report was not a final resolution of anything, and there was no indication at the conclusion of deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree homicide. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted through the end of the deliberations and following. Basically, in this other case, Bluford, the jury had not reached a final determination. In this case, in Karen Reed case, they all did. I mean, at least 5 say that there was a determined verdict. It was final, and there was no more question about it. The defense respectfully submits that this court should hold that Ms. Reed may not be forced to stand trial on a second time for an offense a previous jury found her not guilty of simply because such final unanimous agreement was not announced in open court. Any lack of formality does not supersede the defendant's fundamental constitutional protections. Affirming correction of verdict on one count after receiving a telephone call from 2 of the jurors stating that, contrary to the verdict read in court, the jury had unanimously voted to acquit. Vacated in part on other grounds, United States versus Stouffer. Affirming changing verdict on count where post-verdict interviews of several jurors determined that the jury had intended to acquit. This issue is one of existential importance, not merely to Ms. Reed, but to the foundation of the constitutional safeguards that protect her. So this isn't just about Ms. Reed, this is about the law, double jeopardy. This is bigger than her, and definitely a Supreme Court type of case for them to be looking at it and determining this because this impacts more than just her. Alternatively, the defense is entitled to a post-verdict judicial inquiry to determine whether the evidence supports the juror representations as to having acquitted Ms. Reed. The SJC narrowly construed the right to a post-trial judicial inquiry to substantiate a constitutional violation as limited to claims the jurors were exposed to extraneous information or demonstrated racial or ethnic bias. Under this logic, no defendant claiming that the jury acquitted her but failed to announce that verdict would be entitled to further inquiry no matter how clear and well supported her claim. In other words, even if all 12 jurors submitted affidavits saying they unanimously and finally agreed to acquit the defendant, their failure to announce that verdict and the trial court's failure to inquire if they had any split verdicts, would take precedence over the defendant's fundamental constitutional protection against double jeopardy. So so the SJC and Judge Bev are saying it's more important to have the formality than it is to protect Ms. Reed's double jeopardy rights. The defense respectfully submits that this ruling violates Ms. Reed's constitutional rights. In the analogs context of juror bias, the law is clear that the defendant's Sixth Amendment right to an impartial jury also guarantees the opportunity to prove a claim of bias. Dennis versus United States, Smith versus Phillips. This court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. Thus, a non frivolous claim of jury taint triggers the trial court's unflagging duty to adequately probe the allegation. Trying to understand what that means. Unflagging the duty. I don't know. Non frivolous claims of jury taint triggers the trial court's unflagging duty to adequately probe the allegation. Um, Meaning that the trial court should have probed. Crucially, the trial court does not have discretion to refuse to conduct any inquiry at all when confronted with a colorable claim of juror misconduct. The required inquiry may include the taking of jury testimony because of categorical bar of such testimony on the issue of bias would violate the plainest issues of justice. Think Becky Hill from Alec Murdoch when there was possible jury misconduct or intimidating the jury, trying to influence the jury. They brought in jury members. They brought in Becky. I disagree with what the justices found in her inquiry, but she did bring them in. She said there was no misconduct, but other people said that I mean, it's clear that there was. So I don't know where she got that, but yes, this particular justice brought in the jury members in question and Becky Hill herself and asked questions of them. That's all that needed to be done. And this could have been done immediately after trial and been done and over with. And she could have been acquitted on charges 1 and 3. And conversely, if she's wrong, if the jurors are wrong, then the Commonwealth runs the defense runs the possibility that she might get convicted. I mean, if they all say, "Well, no, we convicted her on whatever." So there's still a what's the word I'm looking for? It's still I can't think. Oh my God, the word I'm looking for. Forget it. It's I can't think of the word I'm looking for. Moving on. All right. So recently, oh wait, where did I leave off? The required inquiry may include the taking of jury testimony because of the bar of such testimony of the issue. Okay, yeah, I read that. Recently, the United States in Sarnaev, that's the guy that did the Boston bombing, right? Sarnaev, or however you say that. The First Circuit remanded the matter for further proceedings in the Boston Marathon bombing case due to two jurors posting on social media regarding the bombings and the district court proceedings, which came to light after the jurors had provisionally selected to serve. The comments did not reflect racial bias in any way, but rather possible bias specific to the defendant. So it doesn't have to be racial bias. It doesn't have to be like ageist or sexist or anything like that. It just could be biased based on, well, she's the only one arrested, so therefore she's guilty kind of mentality. If that were the case, you can bring the jury in and ask them about that, which they did in Sarnia. The comments were also inconsistent with the jurors' assurances that they had not discussed the case online. The First Circuit held that the district court erred by failing to inquire about these issues with the jurors. Given that the right to an impartial jury is a constitutional bedrock, when there is a plausible claim that a prospective juror lied in a manner that may reveal bias, a court need conduct some inquiry reasonably calculated to determine whether the prospective juror did lie and if so, why. So, if there's an issue with a specific juror or specific jurors in a case, you're going to deal with those jurors. So, why in this regard would you not bring them in? I don't know what Bev's thinking was in that. Maybe she wants to go to federal prison. I don't know. All right, so although the district court has broad discretion to determine the type of investigation into juror bias warranted by particular facts, notwithstanding this broad discretion, a district judge does not have discretion to refuse to conduct an inquiry at all regarding the magnitude of the taint producing event and the extent of the resulting prejudice if confronted with a colorable claim of juror misconduct. So basically, if we come to you with a reasonable claim that there is something wrong with this jury process or the verdict or whatever, then the trial judge, cannot refuse to bring them in for an inquiry, a post-trial inquiry. She can't refuse it if there's a credible reason for it. So, crucially, for present purposes, the First Circuit ordered the district court to voir dire the jurors 9 years after the trial. So, time does not matter. However much time takes place between now and, I mean, it's more difficult the more time that goes by, the more difficult it is to call all 12 jurors in, but you can do it. Look, they did it 9 years later. In doing so, the court acknowledged no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also expect that most jurors, having taken time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict that they believe is just, would prefer not to have that verdict disturbed, especially as a result of their own actions. We have no doubt that the able district court judge can do what judges regularly do, form a considered opinion about the sufficiency of the jurors' explanations once those explanations are given and explored. So the trial judge, Bev Canoni, has and can make an opinion based on bringing these jurors in, whether they sufficiently, satisfy uh, her requirements to determine whether or not they acquitted her, basically, is what that's saying. She has the ability to call them in and ask them questions, and based on asking them questions, she can make a decision. Post-verdict inquiry is similarly required to investigate claims of external influence. In Remmer versus United States, after the jury had returned its verdict, the petitioner learned for the first time that during the trial a person unnamed had communicated with a certain juror, who afterwards became the jury foreman, and remarked to him that he could profit by bringing in a verdict favorable to the petitioner. The court, without the defense's knowledge, then enlisted the FBI to investigate. Yeah, you don't want to do that crap. That's probably not wise. The Supreme Court held that the defendant was entitled to post verdict inquiry regarding the FBI's unauthorized contact with jurors. The defense respectfully requests that no less than a conviction rendered by a biased jury or impermissibly tainted by external influence requiring a defendant to stand trial for homicide after a unanimous jury found her not guilty of that same offense would violate the plainest principles of justice. And we have another footnote. The decades old Florida and Pennsylvania state court opinions cited by the SJC involved post trial rendering of guilty verdicts, not acquittals. So again, the SJC is using case law that is not comparable to this case. So it is therefore opposite. Where was I? Indeed, the SJC did not suggest otherwise. Instead, it erected an artificial dividing line between the Fifth Amendment protection against double jeopardy and the Sixth Amendment right to an impartial jury. The defense respectfully submits that this result is not supported by precedent or logic. While the foregoing authorities arose in different contexts, they stand for the proposition that a defendant who comes forward with credible evidence of a serious constitutional violation post trial must be acquitted or must be entitled to an opportunity to prove those claims. There is no apparent reason to artificially limit the availability of such constitutional inquiry as the SJC did to racial bias and extraneous influence. The defense acknowledges that there is little precedent involving situations factually similar to that at issue here. This case is unique. Another reason why the federal Supreme Court might want to be taking a look at this. It is not often the case that after trial, four jurors directly contact defense counsel stating in no uncertain terms that the jury had acquitted the defendant. But the unique strength of the evidence underlying the defense motion to dismiss supports rather than undermines the claim for relief. Contrary to the SJC's characterization, the defense request did not seek to probe the content of juror deliberations. To the contrary, the requested inquiry was directed solely to the result of such deliberations, namely a unanimous decision that Ms. Reed is not guilty of homicide in the second degree. Juror testimony on that subject is not prohibited. Rule 606B bars the admission of juror testimony only upon an inquiry into the validity of a verdict. It does not limit the admissibility of juror affidavits to determine what issues were decided in a prior proceeding. In any event, evidentiary rules cannot extinguish a criminal defendant's fundamental constitutional rights. So basically, this rule that you can't contact the jurors after a trial is so stupid, but there's this rule you can't contact the jurors, and they asked for permission to contact the jurors specifically just to discuss this issue and get affidavits, and they were denied by both Beverly Cannoni and I don't know, maybe the SJC. I don't know if they asked the SJC, but they definitely asked Beverly Cannoni if they could contact the jurors in this case, and they were told no. So this rule that you can't contact the jurors, it exists and it's barring them from being able to find the truth. And it's preventing it's infringing upon Karen Reed's constitutional rights. So there's that. Where do you balance it? In any event, evidentiary rules cannot extinguish a criminal defendant's fundamental constitutional rights. The inquiry requested by the defense here could be accomplished by a single yes or no question posed to jurors. Did you unanimously acquit Karen Reed of the charges in counts 1 and 3, or similar questions that do not intrude into the heart of jury deliberations? Of course, the results of the jury deliberations are not secret. They are, in fact, routinely announced in open court. Here, the defense learned post-trial that the jury reached a verdict that was not announced. It was at least entitled to the opportunity to substantiate that fact in order to ensure Ms. Reed is not unconstitutionally forced to stand trial for criminal offenses of which she was already acquitted. So she's at least she at least has the right to find out if it's true that she was acquitted. She doesn't even know for sure because she's only been able to get 5 jurors to agree to that. She needs the others. So and they're barring her from doing that because of this rule. Such inquiry in no way intrudes on the deliberative process of the jury. Such an inquiry instead honors the jury service, which the trial court described as extraordinary, rather than disregarding the efforts of 5 jurors to disclose that there was not an impasse on all 3 as contrasted to only 1 count. The trial court rejected the defense's repeated requests to order a post-trial voir dire of the jury, where the court could make inquiries that matched what would have occurred if the jury was polled count by count, which Massar Crim P 27 permits, if not prescribes. It, it allows it, but it might even say that this is the remedy. A voir dire that could be structured by the court or the experienced trial court to steer clear of overstepping the boundaries set by Mass Guide Evidence 606B, that could ask about the results of a jury's deliberations without asking about how the jury internally and secretly reached the verdict. Again, this is what we have been screaming from the start when this all took place, the mistrial, and then we got all the affidavits. It is not infringing upon the sanctity of the deliberative process to ask a simple question. You're asking the results. You're asking like they said, they're supposed to be, verdicts are supposed to be read in open court. They're not a secret. So why are they keeping this a secret is the question. They don't want to acquit her is the problem. The First Circuit has entrusted post-trial jury inquiries to the skill and experience of the trial court in matters ranging from extraneous influence to the intrusion of racial or ethnic bias during deliberations. The defense submits that the values at the core of the double jeopardy clause, the primacy of a jury's decision making as a protection for accused citizens against the perils of being prosecuted twice for the same offense for which a prior jury acquitted, is as central to the values of our criminal justice system as is the right to a trial before an impartial and unbiased jury. The defendant has met her burden of production. Far lesser showings, statements by one juror, for instance, have resulted in repeating holdings that jury inquiries are mandated. So in this case, they have 5. And in other cases, there only one is necessary to conduct an inquiry. So why again was she denied the inquiry? Bias. To create an impenetrable procedural wall to this new evidence just because a jury failed to volunteer to the court that its impasse was not as to all counts just because it was never asked is no more principled than to create a similar wall against new evidence of untruthfulness by a juror as in the Tsarnaev case, of racial bias as in Villar, of contact with an outsider, as in Remmer. In each case, the jury could have been polled about outside influence or violating the court's rules by assessing the internet, but that clearly does not result in an absolute prohibition against further fact finding on a showing far less compelling than that at issue here. So, in other cases there's not as much evidence to say that there's something going on or there should be an inquiry. They've brought it in. They've brought the juries in and polled for much less. As in Tsarnaev, the law trusts trial courts to determine whether any of the jurors' answers to voir dire have been affected by media exposure. There cannot be one set of rules for trials with publicity and another for trials without it. The defense respectfully submits that confidence in the courts is eroded by the creation of such an impenetrable wall, preventing jurors from informing the judge whether they voted as to final matter to acquit a defendant of homicide. At a time that public confidence in the judiciary is pivotal, not allowing the jurors to be heard on a matter of such significance and allowing the trial court to decide without taking any action to ascertain the truth of the matter if there was, in fact, a final unanimous, unreconsidered decision to acquit is inconsistent with the elevated role that jurors have long held in our democracy. Damn, that's so beautifully written. Basically, if we're supposed to have any confidence or any faith in our system, you can't just allow this one judge to make the decision without considering all the evidence, all the significance, without considering that the jurors are the ones that we're supposed to be respecting and upholding their decisions. This was really well written. Great job, Martin and Michael. They say, in conclusion, for all the foregoing reasons, the defense respectfully requests that the court issue a writ of habeas corpus and hold that Ms. Reed, her retrial on counts 1 and 3 would violate her double jeopardy rights. So they're saying counts 1 and 3 only. There's issues with the count 2 as well, so I don't know why they didn't try to argue that. And if you follow Brother Counsel at all on his X page, he had said that they should have put count 2 in here as well, especially because the fact that um, they were hung on the lesser charges and that language in there staying like you can still consider these lesser charges if the Commonwealth failed to meet their burden, which I think is a huge error. And I don't think I just feel like that they could have probably fought a little harder for count 2, but I don't know the reasons. I know Martin Weinberg is an excellent, excellent appellate attorney. So I trust whatever reasons he decided, I trust his reasoning and I trust that he knows what he's doing. He's been doing appellate work for quite some time and he knows these justices that he's going to go up against too. And so I think he knows like the best way to get what he needs done, in my opinion. I'm trusting him that all is good. I'm hoping I'm hopeful that they will drop these charges or at least require Bev to call all of the jurors in. But we won't find out until later. So I believe it's March 5th. Don't quote me on that, but we do have a hearing for this with the federal Supreme Court. However, I'm not sure if it's just like a status hearing or if it's oral arguments or what, but there is going to be a hearing on I want to say March 5th, but don't quote me on that. We will definitely update you on that when we have more information. So let me know what you guys think. Do you think that the Supreme Court is going to see this through? Do you think they're going to make some kind of change with the law? I think that they should clarify the law, especially when it comes to these charges and verdict um, or jury instructions that they should be reading. Because if we went back and we looked at this when this happened, the jury instructions that Canoni read were basically the I didn't discover this. This was somebody else who figured it out, but they discovered that the jury instructions, someone on X, I think, the jury instructions that Bev read was actually um, they were actually for single counts for when you have a single charge and she didn't read the instructions for when you have multiple charges and how you determine the um, verdict slip, how you fill out the verdict slip and all that when you have multiple charges. And she did not read the specific language for Massachusetts that you're supposed to. So that might be something that we could look into further if you guys are interested. Let me know what you guys think. Please hit the like button on your way out. And I thank you guys so much for being here and reading along with me. Take care. Bye now.